welcome back to the ISTAT Learning Lab. Today we're going to talk about the development of the Capetown Convention for recognition of rights over aircraft. And to do that, we have in our studio in Dublin today, Maria McElhinney, who is a partner of the Aviation and Transport Group of A&L Goodbody. And she's head of their office in New York, so that's where Maria is normally based. Maria has extensive experience in a wide variety of transactions, international transactions involving aviation assets. And she also lectures on a regular basis for the aviation diploma that is given by the Law Society of Ireland. A&L Goodbody is one of the largest and oldest law firms in Ireland, founded by Alfred and Lewis Goodbody in 1901, so they are 120 years old. And they have worked and continue to work with the Aviation Working Group on the development and implementation of the Capetown Convention. During this learning lab, you can write in questions by clicking the button at the bottom of your screen and write in those questions. And then after Maria's presentation, Mamoon Kuzbari will go over those questions with you. Mamoon is the commercial director of Novus Aviation Capital and based in London. And he's also a director of the board of ISTAT. So with that, I want to hand over to Maria McElhinney.
Thank you, Niels. And I want to just take this opportunity to say thank you to the ISTAT Learning Lab for giving me this opportunity today to discuss the development of the Capetown Convention. Yeah, as Niels said, I'm usually based out of our New York office, but today I am based in Dublin, or I'm working out of Dublin. So I suppose just hold on to just share my screen. Perfect. Can you see that now?
Yeah, that works fine.
Perfect. Okay. So today we're going to go back to basics and really just look at the background to the Capetown Convention and the aircraft protocol. The application of the Capetown Convention itself, we'll talk about the remedies and we'll work through an example. And then we'll also talk about kind of the next steps when it comes to the Capetown Convention with regard to aviation. I suppose since I started out my career in A&L Goodbody as a aviation lawyer, you know, at that time there were few countries that had ratified the Capetown Convention, but you know, since that time there has been numerous contracting states ratified and amended the convention, and as a result the convention has really developed over the last number of years. So I suppose, like, where did this convention come from and why? And at the very outset, I suppose aircraft financing traditionally was an extremely turbulent industry, and airlines often filed for bankruptcy due to high operating costs as a result of fluctuating fuel prices, costly planes, and poor availability of financing. And it was clear that there was a real need for a uniform legal approach towards aviation financing. And with that, IATA and the Aviation Working Group came together and worked together on a new regulatory regime. And through this real hard work and determination came the Convention of International Interests in Mobile Equipment, which we refer to as the convention, and this was signed in Cape Town in December 16th of December 2001. Like, the overall convention itself applies to different asset classes, so it applies to aircraft, rail assets, space assets, and actually of more recent, there will be an introduction around mining, agriculture, and construction equipment. But there is a protocol then on the convention specific to aircraft equipment. So we call this the protocol. And again, this was also signed in Cape Town in December 2001. But the convention with the protocol, the aviation protocol, which is what we will discuss, came into force on the 1st of March 2006. As few as maybe 10 contracting states existed around 2006, with the US and Ireland being one of the first entities or the first countries to ratify the convention. Now, March 2022, there's 83 contracting states. So it has come a very long way over the past years, with United States, Ireland, UK, and China among the main contracting states, and notably non-contracting states includes Germany and France. So this is just kind of to emphasize, I suppose, the breadth of the implementation of the convention with regard to the aviation protocol. And the green in this map just shows the vast number of contracting states that have ratified the convention, and it has entered into force, whereas the yellow orangey color is those that have signed but have yet not implemented the convention into their law. So then, like, just, I suppose, aircraft financing, you know, was extremely turbulent, so they needed to create this regime. So I suppose one of the main objectives around the convention is to establish a commercially orientated uniform set of international rules relating to the creation, registration, priority, and enforcement of security and leasing interests in aircraft objects. And the benefit of this is really enhancing the legal predictability of cross-border transaction. So this in turn reduces any creditor's risk when they are financing, because there is a predictable set of security laws. There's lower funding costs, and as a result, greater access to finance. So I suppose the lower funding costs, you know, we have seen, particularly where it comes to something like EXIM financing, where, you know, the financing is being provided to contracting states that have made certain declarations, you know, they will avail of, or they can avail of like a reduction in the exposure costs or the costs around the financing. And the impact of that is that, you know, it's basically you will see the Cape Town Convention mentioned and referred to and implemented across the vast majority of aircraft financing and leasing deals. And just given the extent of the number of countries that are a party to the convention, you know, it's seen across you know, the vast majority of the deals that we come across on our desk on a day-to-day basis. So it is a really important convention for the aviation industry. So then, just to look at what does the convention do? So what it does is identifies and creates uniform categories of interests which can exist in aircraft objects. It allows for these interests to be registered on an online system, which is publicly available, and allows for standardized default remedies to apply in each contracting state. And it's the innovation around the online registration and the default remedies that has really been one of the key aspects of this convention. So now what we'll do is just look at, I suppose, when does the convention apply and how does it apply to a particular asset and in relation to a particular transaction. So in order for the convention to apply, the object in question must be deemed to be an aircraft object under the convention. So what is an aircraft object as it's defined in the protocol? So it's an airframe that's able to transport at least eight people, including crew, or goods in excess of 2,750 kilograms. It's an engine having at least 1,750 pounds of thrust. And then helicopters that are type certified to transport at least 5 persons, including crew, or goods in excess of 450 kilograms. So if your object that you are financing or leasing falls within any of the definitions of aircraft objects under the protocol, then you need to understand that the convention then may apply. Depending on I suppose the next set of circumstances or facts that we'll run through. It is worth noting that engines of helicopters are only aircraft objects where they're not installed in the helicopter. So where they are installed in the helicopter, it's just part of the helicopter itself. So then the most common types of interests in aircraft objects that can be registered are international interests, sales, and assignment of international interests and its associated rights. So what we'll do is go through each of those international interests and talk about the connecting factors for each, and whether as a result of these connecting factors, the object that you are financing or leasing would be eligible to fall within the convention itself. So firstly, if we look at an international interest, so an international interest under the convention is an interest granted by a chargeur under a security agreement. So this is, for example, if you are financing or a bank is lending a borrower money, the borrower owns the aircraft and the borrower is providing security to that lender, that borrower would be deemed to be the chargeur under the security agreement. So it is the person that is granting the security over the aircraft object. An interest held by a lessor under a leasing agreement, so it's the lessor as opposed to the lessee. And then an interest held by a person who is conditional seller under a title reservation agreement, so often a bill of sale. So the seller under the bill of sale. So they are the 3 types of international interests. Then we'll look at the assignments of associated rights. So this is the right to payment or any performance under an agreement which is secured by or associated with an aircraft object. So where we typically see this is an assignment of rights under an aircraft lease. So typically in aircraft financing, you would have, you would provide security over the aircraft itself, so the airframe and the engines. And in addition, you would also provide typically an assignment over the lease. So the lessor would provide an assignment of the lease in respect of that aircraft. And that would usually be deemed to be an assignment of associated rights. So the assignment of the lease itself isn't registerable independently, but if the lease is an international interest and is registered on the international registry, then you would also register the assignment of that lease in favor of the creditor. The next international interest then is a sale. So it's typically not deemed to be an international interest in itself, but the protocol extended certain registration and priority provisions of the convention to sales. So where you have a sale of the aircraft, this can also be registered on the international registry. So it's typically, you'll see a bill of sale being registered rather than a sale agreement itself. So those are the three types of international interest. So you've got your charger assigning its interest under a security agreement, a lessee or a lessor in respect of a lease agreement, and the assignment of that lease, and then you've got the seller under a contract for, or a bill of sale. But in order for an international interest to exist and for the legal and factual test to be satisfied, there are 4 criteria that needs to be met. The first being that the agreement is in writing. Now, typically that's an easy one to meet. You know, your security agreement over your aircraft or your lease agreement is, you know, going to be typically in writing, so it's an easy one. The agreement must relate to an object of which the charger, conditioner, seller, or the lessor has the power to dispose. So the power to dispose, I suppose, is a broader term than just the right to dispose. But in order for the international interest criteria to be satisfied, that the entity must have the power to dispose. The agreement itself must describe the aircraft object by the name of the manufacturer, this manufacturer's serial number, and the model designation. So where you're looking at your security agreement or your lease agreement to try and determine whether an international interest exists, you should make sure that, you know, the aircraft object is described properly by way of the name of the manufacturer, the serial number, and the model designation. And then with regard to the security agreement only, the secured obligations must be able to be determined. So this would typically be by way of, you know, in a security document, what would often be the case is that the charger would secure all obligations owed by maybe a borrower under a loan agreement. So if when you're looking at your security agreement, you can determine what obligations are being secured by the security agreement itself, then you should be able to meet the test in number 4. So then the next step, okay, you have your international interest, you think it's okay, it ticks the boxes with regard to the legal and factual tests, then you should move on to what is the connecting factor. It's probably just worth noting that where you have non-compliance with any of those 4, well, in respect of security agreement or any of the first 3 with regard to a sale or lease, you know, if you don't have compliance with all of those factors, then an international interest isn't created. And, you know, if a registration is made, it'll be deemed to have no effect. Okay, so then the next step is really to determine, okay, does an international interest exist by way of the connecting factors? So in order for an international interest to exist, one of the 2 following connecting factors must exist. The first is that the debtor is situated in a contracting state. So if the debtor is situated in a contracting state, and you know, it's worth remembering now that there are 83 of those connecting states as opposed to maybe at the start where there were maybe only 10. So, you know, given the kind of width breadth of how the convention has been implemented, in vast majority of financings and leasings that we now see in the aviation space, a debtor is often situated in a contracting state. And if the debtor is in a contracting state, the convention applies to both the airframe and its related engines. The other connecting factor, if the debtor isn't situated in a contracting state, is to look at the state of the registration of that airframe. So if the convention applies in relation to an airframe, it applies only in relation to an airframe where the airframe is registered in a contracting state. So in an instance where, for example, the the airframe, for example, is registered in Ireland, but the debtor is situated in France. France isn't a contracting state, so it wouldn't fall within number 1. But given that the airframe is registered in Ireland, it would fall within the state of registration being a contracting state. And in those instances, it's the airframe only that you would make a registration against, so not the engines. And the reason for that is that it's only the airframe that's registered in the contracting state. The engines aren't registered in a contracting state. Then to look at, well, who is the debtor? When we talk about a debtor situated in a contracting state, and the debtor is a chargeur under a security agreement, a lessee under a lease agreement, or a seller under a bill of sale. So if your chargeur under a security agreement is situated in a contracting state, you've ticked the connecting factor base, the lessee in a lease agreement, or the seller under a bill of sale. So then just when is a debtor situated in a contracting state? So it's broader than just where I suppose the debtor is incorporated in a contracting state. So the debtor is situated, if they're incorporated in a contracting state, they have a registered office in a contracting state, they have a statutory seat in a contracting state, or its center of administration is in a contracting state. The easiest way to, on the contracting state is around incorporation, because incorporation is just a factual, yes, they are incorporated there, and we tick that box. Registered office, something similar, depending on whether, depending on the state of the registered office, whether there's a requirement to make a filing, maybe in a company's house or company's registration office. The statutory seat or the center of administration is more a question of I suppose, what activities that that debtor is carrying on in the state, in order for you to be able to determine that the center of administration is in the contracting state. I suppose what we used to see here was, where maybe you had a company that was incorporated in a non-contracting state but was tax resident in a contracting state, and that would trigger a connecting factor. So if you think back to the time where maybe Bermuda wasn't a party to the Capetown Convention, but you often had structures where the borrower was resident or was incorporated in Bermuda, but had a registered office or was tax resident in Ireland. And in those instances, the connecting factor would be established because the company would have its tax residency and a registered office in Ireland, which was a contracting state. One of the real key factors and something to be very aware of when it comes to the Capetown Convention is that the rule on first to file has priority is a key one. So registrations are made by parties without documentary verification. So it's the interest that is registered rather than the document recorded. So when you go to make a registration on the International Registry, there's no requirement to show any document, and you just make your registration. And it's first in time has priority. So the date of registration is key. And registered international interests have priority over unregistered international interests, even where the registered creditor had notice of another creditor's prior but unregistered interest. This, so it's, I suppose as a transactional lawyer or if you're in charge of making the filings on the international registry in respect of international interests, it's really important that the filings are made as soon as possible. And whether that's just on closing or if you're carrying out prospective filings. But given that first in time has priority is a key factor, you do not want to be in a situation where, I mean, your financing has happened, your security has been granted, your lease has been granted, a filing hasn't been made, and a subsequent filing happens afterwards. And unfortunately, in those situations, the registered international interest will take priority. So I mentioned about when to make the filings, and I suppose you can make a filing, an international interest filing, at the time that the security agreement is entered into, the lease agreement is entered into, the bill of sale is complete, and they are known as international interests. But you also can make prospective filings. So that's a prospective interest. And a prospective interest can be made where the object is identified and there's evidence of an international interest event happening. And these prospective international interests are registerable. There's no further act required to give rise to the creation of the international interest. It's a case of, you know, once the security agreement is dated or deemed to be effective, the lease agreement is deemed to be effective, etc., that prospective filing automatically becomes an international interest. The date of registration of the international interest will be taken as the date of registration of the prospective international interest, and prospective sales are also registerable. It is important to note, though, that if you were to look at a search, like a priority search certificate from the International Registry to see what filings have been made in respect of a particular aircraft object, you wouldn't be able to determine whether it's a prospective international interest or an international interest. I suppose the reason for prospective, for the ability to make prospective filings is that, you know, because of the priority rule, it's maybe to get in prior to anyone else, where there are no other filings made on the International Registry in respect of that aircraft or aircraft object. Probably it's worth stating, though, that from a pure practical perspective, we would rarely see prospective filings being made. And that's probably just due to the fact that, you know, if the deal doesn't happen or the transaction doesn't close, or the lease isn't granted, then you have these filings on the International Registry that, you know, needs to be released. And often people, or like the owner of the aircraft, or won't want to have these filings made against the object until the actual transaction or lease or sale becomes effective itself. So, I mean, we can make these filings on the International Registry when, you know, the security agreement is released or a lease agreement has terminated, and there is the ability then to discharge the international interests that have been made. So the right to discharge defaults to the creditor of an interest, so that would be the lender under a security agreement or the lessor under a lease agreement, but they can be assigned to another entity. So I suppose from a practical perspective, what we would often see is an international interest in relation to a lease. So the Lessee is the debtor in respect of an international interest on the lease agreement. The lessor is the creditor, so the right to discharge would by default automatically go to the lessor. But if that lease is being assigned by way of security to a lender, the lender will often want that right to discharge. So there is the ability to assign the right to discharge to a new lender or to another entity, and we would often see that as the case in aircraft financings, where the right to assign is assigned to the lender or the creditor under a loan agreement. Where you're looking at your international or your priority searches in respect of filings made against an aircraft object, it's worth noting that there isn't, once you discharge an international interest, the international interest on the search doesn't kind of fall away. It stays there, but a subsequent entry is added, which notes that the discharge has been made in respect of that file. It is important to just check the effective time of the discharge, and then contracts of sale, they cannot be discharged unless they were registered by way of a prospective filing. So we've talked a lot about making filings when we have an ability to make a filing, where the international interest is created, where we have the connecting factor. But I suppose it's just worth talking about where these registrations are actually made. And the interests or the registrations are made on an online system called the International Registry. And it was established by the Capetown Convention and supervised by the International Civil Aviation Organization. And I've put the website up there to show where it can be accessed. And it's really important to note that, this system is a really user-friendly system. So, the establishment of this electronic system was one of the most important elements of the convention itself. So for the first time ever, you had the ability to search and file interests online, and this international registry is available 24 hours a day, 7 days a week, 365 days a year. So if you are a financer or a lessee, and you're looking at, financing this aircraft or potentially buying an aircraft or leasing an aircraft, you have the ability to go on to the international registry, key in your MSN number or your ESN number, look at the searches to determine whether any other party has an interest in the aircraft object. And from a financing perspective, it gives the financer comfort, if the searches are clear, that there are no other rights or effects that could affect the value of the asset, or there are no competing rights for security rights for that aircraft or engine. It's also worth noting that the International Registry is constantly improving. They meet regularly to discuss how the process of filing and how the website can be improved and be as simple and efficient as possible. I mean, since I've started out kind of making international filings quite a number of years ago, you could make one filing at a time against one MSN or engine, and it was a long drawn out process in comparative to now, where you have your closing rooms, you can make multiple filings against an MSN or an aircraft object at the one time. So there has been the International Registry itself has advanced so much over the years, and it really has become so much more efficient and simple in its use. but again, they are constantly evolving and are trying to make this system as easy as possible for its users. So then just, I mean, who makes these registrations on the international registry? So the approved registry users are known as transaction user entities. So these are the entities involved in the filings, or where the filings are made against them. So that would be the debtor, creditor, assignor, assignee, the buyer, seller. Or you can have a professional user entity make the filings on your behalf. Step back and from a really practical perspective, you know, where you're working on a transaction that you know, falls within the Capetown Convention, and there will be a requirement to make filings on the international registry, it's worth checking the international registry at the outset just to make sure that the parties where filings will be made against on the international registry, that they are set up on the international registry as a transaction user entity. You know, sometimes the party can, like, can expire, or it needs to be set up from scratch. And although the turnaround in setting an entity up as a transaction user entity is fairly fast, you know, you don't want to be in a situation where, you know, closing is happening in 5 minutes time, and you know, that you've just realized that the entity hasn't been set up on the international registry. So it's just a real practical point. It's also just worth noting when it comes to registrations that every contracting state has a number of choices to make as to which declarations it will make as part of its ratification. And one of these choices is whether, you know, there's a requirement to have an authorized entry point in order to make registration. So, you know, whether a code, which we often refer to as an AEP code, is required to make a registration. So, you know, when it comes to aircraft that are registered in China, Brazil, UAE, USA, Spain, Mexico, Albania, Ukraine, Vietnam, Argentina, there is this requirement to have an AEP code prior to making the registrations. It's really important that, you know, local council in those areas are appointed to assist with compliance on the entry point requirements early on in the process. And what, you know, there are differing rules applying in different jurisdictions. So it is important to engage early, just in case there's a requirement to have original documents versus certified copies versus notarized documents. And I mean, during COVID, we really saw that, you know, sometimes the provision of original wedding signatures or notarized documents could take quite a long time, just given that a number of the parties maybe signing the documents weren't in the office or were working from home. So it is always good, just from a practical perspective, to make sure that, you know, you are engaged with your local council in those areas, just to get advice as around how you obtain those codes and you know, what the processes involved are. So we'll now move on from, I suppose, the how to create an international interest, what those connecting factors are, how you go about making the registrations in the international registry, and move on to, you know, the provision of remedies. And the provision of remedies in the Capetown Convention is really, it really lies at the heart of the convention itself. So having adequate remedies is really important for any creditor in an aircraft transaction, because they must be confident that they have the ability to exercise a default remedy with speed and ease. And the convention itself provides 4 remedies for default with respect to aircraft objects. So what would typically happen is the parties would agree what events would constitute a default under an agreement. So typically, if it was a security document, you're talking about non-payment, breach of contract in a lease, breach contract of the lease itself. And the remedies are supplement to existing remedies provided by domestic law. They're in addition to contractual remedies to the extent compatible with the convention, and then they may be enhanced in an insolvency by the contracting state adopting the Capetown Convention Alternative A, which is a creditor-friendly type insolvency regime, or Alternative B, which is more discretionary. We spoke about the 3 kinds of international interest. So you have your chargeur under your security agreement, your lessor under your lease agreement, and then your seller under the title reservation agreement, your bill of sale. And as a result, of those 3 international interests, there's different remedies applicable to depending on the international interest that you're relying on. So where we look at a security agreement, the chargee can exercise a number of remedies, such as taking possession of the aircraft object, sell or grant a lease of the aircraft object, collect or receive income or profits arising from that secured aircraft object, or were agreed between the parties to take ownership of the secured aircraft object towards satisfaction of the secured obligations. So here we're talking about, if there has been a breach, say, for example, of a loan agreement, the borrower, the aircraft owner, has provided security over that loan agreement, the obligations under that loan agreement by way of a mortgage over their aircraft. There's a breach, then the chargee or the lender or the security trustee, can, where it is an international interest has been created, the Capetown mortgage is in place, then they have the ability to take these remedies against the underlying chargeur or security provider. Then the remedies under a title reservation agreement or a lease. So, the conditional seller or lessor can terminate the agreement and take possession or control of the aircraft object to which the agreement relates. So in a lease, you terminate the lease and take possession or control of that aircraft to which the agreement relates. It's probably just worth mentioning at this stage, because I'm sure it's on a lot of people's minds. Over the last number of weeks, and I suppose we heard at the Learning Lab last week about the sanctions that have been put in place, and particularly the EU sanctions, where it came to the termination of leases, to Russian carriers, and all of those leases were to be terminated by the 28th of March, which was Monday. And, we all know, although those leases have been terminated, that, although Russia is a party to the Capetown Convention, that the aircraft haven't been repossessed, or the Russian Federation hasn't allowed for those aircraft to be repossessed in all cases. So, the AWG have made a statement, or have come out with a statement, and it is published on the Aviation Working Group website, that clearly states that, that Russia has breached the Capetown Convention. They signed up to it, and by signing up to it, you're kind of stating that you're going to implement all elements of the Cape Town Convention, including these remedies. But to date, the kind of activity that has been happening in Russia has shown a complete breach of the Cape Town Convention. It's unclear what next steps will be, and there's still a lot of questions there, so I don't have the answers as to how it'll be remedied. But it is worth just having a look at the AWG website and reading through the statements that AWG have published in relation to Russia. And it just clearly sets out where they feel that the breaches have arisen. It doesn't talk about next steps, but it clearly shows that there has been a breach of the Cape Town Convention. I suppose in addition to the remedies that we just spoke about, there are also 2 further remedies that were introduced by the aircraft protocol, and that is the ability to procure the deregistration of the aircraft from the relevant aircraft registry, and to procure the export and physical transfer of the aircraft from the territory in which is located. So that is a self-help remedy that comes about by way of an IDERA, which we will speak about in our next slide. And the second remedy then is to apply to the court for interim relief orders in respect of the aircraft object for preservation, possession, immobilization, leasing, or sale. So this is where you go to the court, usually in the jurisdiction where the aircraft is located, to around obtaining possession or leasing or sale of that aircraft. So an IDERA, so we mentioned this is a self-help remedy where so the IDERA is an irrevocable deregistration and export request authorization. So it does what it says in the tin. It is there to allow the authorized party permission to effect a deregistration and export the aircraft without any further consent of the registered owner. And I suppose the rationale behind an IDERA is it really is there to like decrease the risk of financing aircraft. So creditors really need to be able to quickly repossess aircraft and like on a default and have that ability to to redeploy those aircraft in order to generate income. And the IDERA was designed by the convention to address this. So in effect, where there is a breach or there is a default, the IDERA will be signed by the registered owner, will typically be registered in the aviation authority of the country where the aircraft is registered, so it's on the file there. The IDERA will say that it kind of authorizes another party to, on a default, to have that aircraft deregistered from the aviation authority or deregistered from their name and export of the aircraft. So it is really important, where IDERAs are obtained as part of a financing, that the original of those IDERAs are sent to the relevant aviation authority as soon as possible after closing or on closing, because an IDERA will typically be, the authorized party to deregister will often be the creditor or a lender under a financing arrangement. So it's, in order to perfect the IDERA, it should be registered with the aviation authority, and then if there is a requirement, that aviation authority will comply with the IDERA and deregister the aircraft. Just worth noting as well, I suppose, that the quiet enjoyment is part of the Capetown Convention. So, you know, in the absence of a default, the debtor is entitled to quiet possession and use of the aircraft object in accordance with the agreement. So I suppose it often applies in respect of a lease. So where you have a debtor in a lease being the lessee, and they will have the ability to, you know, use the aircraft and be entitled to quiet possession of that aircraft unless there is a default under the agreement. And that's regardless of the fact that there is an assignment, or there may be an assignment of that lease to a lender as part of the security provisions under a loan agreement. I suppose we've kind of gone through kind of the background to the Capetown Convention, how it works, and I suppose in legal terms. But now I thought it just would be worthwhile to do a quick run through of an example, just to show where from a practical perspective, you know, the international interest that would arise and the filing of those interests. So, I mean, I've just picked a typical kind of leveraged lease financing transaction. So in the center here, you've got your owner trustee, or typically your borrower, who is the owner of the aircraft. They have lease the aircraft down to the lessee. You know, there's a seller here that is selling the aircraft to the owner, trustee, or borrower. The financing for the aircraft has been provided by this lender, and as part of the security package for the note issuance, the owner trustee is required to provide an indenture or a security agreement over that, over the aircraft and the engines in favor of the lender. And typically, as part of this indenture, you would have security over the aircraft itself, but also you would have an assignment over the interest that the owner trustee or borrower has in the lease itself. We can ignore kind of the assignment of the purchase agreement and the note agreement as well. So when we think back and we think about the international interests that arise under the Capetown Convention, you know, where we look at this example, I suppose the possible registerable interests are this lease agreement. Seems to have lost its name, but this is the lease agreement between the owner trustee and the lessee. So there's potential that the lease agreement constitutes an international interest. This security agreement or indenture that has been provided, you know, could constitute an international interest as both a security agreement and an assignment of the international interest constituted by the lease. And then the bill of sale could also constitute a contract for sale. But in order for these possible registerable interests to become registerable interests, you know, the connecting factor must exist. So what is the connecting factor? So I suppose the things that we would look at is the seller situated in a contracting state? And if the answer is yes, then the bill of sale could be registered. Is the owner trustee situated in a contracting state? Again, if the answer is yes, then potentially the indenture or the security agreement is an international interest. And then is the lessee situated in a contracting state? So the lessee, the owner trustee, the sellers being the debtors under the agreements, and then the contracts being the bill of sale, the indenture, and the lease agreement. If the answer to any of these is no, so if one of these parties is not situated in a contracting state, then where is the aircraft registered? Is the aircraft registered in a contracting state? And if the answer is that yes, that maybe the seller isn't situated in a contracting state, but the aircraft is, then the international interest would be in respect of the contract for sale, in respect of the airframe only. So then the potential registrations are, as we spoke about, if seller is situated in a contracting state, the bill of sale covering the airframe and engines, listing the seller as the seller and the owner trustee as buyer. If the owner trustee is situated in a contracting state, then the international interest in respect of the indenture, covering the airframe and the engines, where the owner trustee is listed as the debtor, and then the lender or the indenture trustee is the creditor. Then if the lessee is situated in a contracting state, the international interest in respect of this lease covering the airframe and engines would be registered. And then the assignment of this lease would also create an assignment of an international interest. And that is regardless of whether the owner trustee is a party, it's if the lessee is situated in a contracting state. So that's just a real quick practical example of, I suppose, what we would typically see in a leveraged lease transaction, and the Capetown registrations that would arise as a result of that transaction. So I suppose then next steps as to maybe like what is next when it comes to the Capetown Convention. It has come a very long way, and there are contracting states ratifying and acceding to the convention on a regular basis, and with that will come kind of questions from those new states as to how to implement the Capetown Convention, and AWG do an amazing job in that role of educating new states when prior to and on ratification as to how the Capetown Convention should be implemented. The Capetown Convention overrides national laws as like for matters within its scope, but you still have to rely on national laws for the practical realization of the Capetown Convention benefits. But AWG do a great job in that role in education on implementation. COVID, definitely during COVID, we saw a number of cases being brought through the courts, particularly around the alternative A remedy, and these cases can be reviewed on the AWG website in the legal activity sector, but there were, I suppose, gaps that will now be kind of will now be dealt with in the official commentary update that is due to be published very soon. So things like questions around recognition of trusts, and the official commentary will have further clarification around trust. So that's something to watch out for over the coming months, because it will give further clarification on parts of alternative A and around trusts. But it is, I suppose, safe to say that the convention has really developed and enhanced the number of aviation financing transactions that have occurred, and no doubt in my mind that, you know, that will continue to apply over the years. It has been a real changing factor for the aviation financing or the aviation industry as a whole. And it really, you know, given the number of contracting states that have now ratified or acceded to the convention, really shows the width and depth of the convention itself. And I think, you know, it has been great for the industry and will continue to innovate and evolve over the coming years. So with that, I will hand it across to Mamoon just to talk through any questions.
We can't hear you, Mamoon. You look to be unmuted.
Hear me now?
Yeah, that was good. Thank you.
Okay, sorry about that. Thank you, Maria, for this very comprehensive and complete update on the Cape Town. So we did get a few questions. I'll start with the one that is a little technical for you, Maria. So Julie is asking, when IR filings have already been made in relation to an aircraft, and new filings need to be made as, for example, new securities are being granted, in order to comply with the priority order, with the practice to deregister the existing IR filings and make a new set of filings in line with the priority order, or to file subordinations? If the deregistration and registration is made in a closing room, is the beneficiary of the IR filing being deregistered and re-registered being prejudiced in any way?
Okay, thank you. Julie, yeah, I mean, there are two, like, you've probably called out both ways in which it can be done. It's often a case that existing filings, so where, maybe I'll take a step back and say where this often arises is where a lease agreement has been entered into between the owner of the aircraft and the lessee. That lease has been registered on the international registry, and then perhaps a subsequent security or loan is provided, like a refinancing of that aircraft is provided, and there's security provided by the owner of the aircraft to the lender, and that will constitute an international interest by way of the mortgage. So you have an existing lease that is registered versus a mortgage that, you know, the creditor will want to have priority over. So what we've seen in the past is both a deregistration of the lease itself and a re-registration after the security has been registered. And I mean, that will come down to, I suppose, preference of the parties and the ability or the willingness of the lessee to have, you know, the filing released and re-registered. Sometimes it is, although it makes the filings and the international registry the filings made on the international registry a little complicated, it is sometimes easier just to have a subordination agreement put in place and to file that subordination agreement in the international registry to show that perhaps the security document or the mortgage has priority over an existing lease.
Maria, could you stop sharing your screen now so we can see more of you?
Oh, yes, of course.
Thank you. Perfect.
There we go.
Yeah.
Okay.
Mamoon, was there a second part, sorry, to that question that I may not have?
Julie's asking if there are any any parties being prejudiced against if it's done in a closing room or not.
No, I suppose the closing room, they shouldn't be prejudiced. If all of the parties are happy that the international interests or the registrations are to be made, then there should be no prejudice using a closing room. And I mean, I think the closing room is probably one of the best features that have come out of the International Registry over the last few years, and it just makes filings much simpler. The closing room can be set up prior to a closing and then released on closing, so that the registrations take effect at this, the same time, but in the order of priority that the parties have agreed to.
Thank you very much for that. Now, more general question, and this is both linked to the current situation in Russia and Ukraine. So, two similar questions is: what will be the impact of the conflict in Ukraine on the effectiveness of Capetown, and how can Capetown offer lessors any help, with the aircraft trapped in Russia? So, I appreciate this is very high on the agenda for a number of people, and we did touch upon it in the AWG article that you mentioned as well.
Yeah, so I mean, there's no real public knowledge or knowledge that I know of lessors taking a case against the Russian Federation for a breach of Capetown. And all we've seen is the AWG have made their statements around the fact that there is a breach of the Capetown Convention. How that will play out is really a matter of time. I don't have any future crystal ball gazing or anything that I can do there. I would assume that the lines of communication there are still open. The leases have been terminated, but you would think that just there would be a line of communication between Russia and maybe AWG just along those lines. But I have to say I don't know what the future will be with regard to what the consequences of the breach by Russia of the Capetown Convention will be, and it's something that we'll all be very eager to see and watch over the coming months.
Is this the first breach that you have observed under Capetown?
Yeah, where there just a complete lack of communication, and the breach, they've breached the convention in numerous ways. The fact that they've had total disregard for the convention, where they're telling the airlines not to give back the aircraft, where they are actually asking other contracting states where an aircraft is located to not comply with the convention, and then the whole piece around the registration, to dismiss the fact that the aircraft are registered in Bermuda or Ireland, and to have a kind of dual registration in Russia, goes against the complete implementation and compliance with the convention itself. So yeah, it's the first time that the Capetown has been breached in that way.
Has it been tested though in other situations?
No, I mean, in other situations, there's definitely been, there's quite a lot of case law out there, where the national courts maybe have implemented Capetown in the way that that it was supposed to, but those cases have been reviewed, and there's summaries on the AWG website. But no, there's no breach that kind of is anything like this.
But do you have examples of episodes where you would say that the ability to recover your collateral has worked better because the country had ratified the convention?
I don't have specific examples, but I mean, mainly because the Capetown Convention has been complied with, and as a result, there hasn't been any future litigation on that piece. So I mean, there are definitely creditors that have relied on the remedies under the Capetown Convention and have had their aircraft redelivered to them without needing to go to court, or without needing to get completely involved in the complexities of differing security arrangements in different jurisdictions. So yeah, I don't have an example that I can point to, but you know, the Cape Town Convention has definitely been used in practice.
Sorry.
And how do you see the evolution of Cape Town, especially in view of what's happening in Russia now? Do you see, you know, obviously all of this is based on a convention. Do you see changes to that convention that could come because of what's happening in Russia, or will the main changes to Cape Town be of a more technical nature, as we saw in the registry with the closing room and those sort of additional advantages?
Yeah, I mean, I suppose when a country is ratifying the convention, it's not just something that they can, you know, rock up and decide that they'll accede to the convention and everything is in order. I mean, it takes time, you know, and the contracting state, you know, is signing up to the fact that they will implement the convention, and there's a lot of work and education that goes into ensuring that, you know, the contracting state is well aware of what they are signing up to. It is you know, it's implemented into national law. And I mean, Russia did all of that. It ratified the convention, or it acceded to the convention. It made a declaration that it would implement it, and I suppose it has gone rogue. And I mean, there was, you know, I think when Russia did accede to it, you know, it was seen as a good thing, because they were kind of stating that they were going to implement the Cape Town Convention properly at the time of ratification. So it's just, you know, this was never something that was thought was going to happen. I'm sure there will be ramifications for them going forward, or and we'll wait and see what they are, or if there are any. But I don't see the, you know, the ratification or implementation or acceding to the convention is changing. And I think where we will see changes is probably just, you know, as technology advances, or there's innovation, like with regard to, say, you know, GATS is, you know, the big thing now when it comes to aviation transfer and sales, and you know, the commentary, that the revised commentary that is coming out in the next couple of months will kind of give further information and clarification around trust. So I do think that, you know, the convention will evolve as technology and structures change, as opposed to maybe how they go about ratifying, or contracting states ratifying the convention itself, because you do need to take the word that, you know, when they're signing up to this, it's not a small gesture. It's, you know, the work has been put in behind the scenes before any country ratifies or accedes to the convention itself.
Any question, Niels?
Yeah, I have a few more questions. You mentioned in the beginning of your presentation that the convention would remove some jurisdictional risk, although maybe not country risk so much as we've seen now in Russia. But do you have any, have there been any studies made on how the implementation of the convention has reduced pricing for the debtors?
Yeah, so I mean, we've definitely seen that when it's come to EXIM financing. You know, at EXIM financing, there is a discount applied where the contracting, like the airline or the lessor, the holder of the aircraft that's being financed, is party to the Cape Town Convention, or is a contracting state, and in a contracting state, and they've made the relevant declarations under the convention, you know, a discount is then applied to the fee that EXIM would receive for the financing. So you know, that is a specific, like, clear example of a discount that's applied and the benefit around the borrowing costs. Other examples are probably things like, you know, because there's especially downtown, there's, you know, a legal system that has kind of, you know, occurred, and there's precedents there, that there's probably a legal cost that isn't as expensive as it was maybe prior to the convention. There's also kind of like, given that there is the predictability on you know, the legal implementation of you know, security, and the creditors are taking on less risk where you know, they have that predictability around security, then they're, although they might not call it out like Exim does, you know, there is there's probably a reduction in cost for the borrower there as well.
But that's bad news for you, isn't it? As a lawyer?
Lawyers will always be okay, Niels. No, I mean, it definitely, with the Capetown Convention, you know, it has meant that there has been more aviation transactions. So, I mean, more transactions means more work for lawyers, so they'll be happy.
Okay. Well, any other questions, Mahmood?
Just one regarding the slides. Will this be available? I always struggle. I always forget. Do we provide the slides?
Yeah, I think first of all, there would be the presentation will be on YouTube. I think tonight or tomorrow, and then the slides should be available on the ISTAT portal.
Yeah.
Yeah. Okay. On that happy note, and I'm happy, Maria, that you will always be okay. Thank you so much for that interesting presentation, and we'll see you back, all of you, on next Tuesday, 5th of April, same time, and then we're going to have Nico Buchholz talk about how airlines select airplanes, so fleet planning. So see you back then. Thank you very much.
Thank you so much.
Thank you, Maria. Thank you, Niels.
Bye.